figure this out so it works. Can you hear me? Okay. Thank you for coming. My name is Jenna Davis, and I'm the CEO of the Cook Islands Financial Services Development Authority. We're going to talk about the Cook Islands this afternoon as an offshore finance center and get into some more specific information regarding asset protection. I'll turn that over partway through to Antony Will, who's the Managing Director of Cook Islands Trust Limited. The Cook Islands has a motto of last heaven on earth. That's a picture of the main island where the trust companies are located. A lot of people have been asking this week, where are the Cook Islands? As you can see, they're northeast of New Zealand, south of Hawaii, equidistant from the equator. In 1888, they were a British protectorate. In 1901, they became part of New Zealand. And then in 1965, they became self-governing. And they are what is called in free association with New Zealand. And what that means is that Cook Islanders hold New Zealand passports. They're New Zealand citizens. And New Zealand is supposed to take care of the Cook Islands' defense and foreign affairs. The reality is they don't need any defense, and they handle their own foreign affairs. And they are part of the Commonwealth. Oh, going the wrong way. The Cook Islands are part of Polynesia. As I just noted, they have New Zealand citizenship. There's about 17,500 people that live in the Cook Islands, with 10,000 on that main island that I showed you. And there are 80 to 100,000 that live overseas. Cook Islanders are very educated. Most of them have done their education, secondary and tertiary, in New Zealand or Australia. In terms of the trust company employees, we have a very active law society and Cook Islands Accountants Group. Most of the attorneys are from New Zealand. There's a couple of us, myself included, that have been to law school in the US, Australia, the UK, other places. And we are one of the newest STEP chapters. So for those of you not familiar with STEP, it's the Society of Trust and Estate Practitioners. We have a democratically elected parliamentary Westminster system, very similar to New Zealand, the UK, some of the territories in the Caribbean. We have a 24-member parliament. We have a prime minister. Our ultimate court of appeal is the Privy Council in New Zealand. And we have New Zealand High Court, in the UK, I'm sorry. And we have New Zealand High Court judges that sit on the courts. And the financial services sector began about 30 years ago. It was largely born out of demand from corporations in New Zealand and Australia. They were taking advantage of tax loopholes, and it was essentially a lot of company work. And eventually those tax loopholes closed up, and the Cook Islands had to figure out, what do we do to differentiate ourselves, and what services can we offer going forward? And what they did at that stage was create asset protection provisions that they included into their Trust Act, which Antony will go into more detail about. And today we offer trusts, foundations, companies, LLCs. We'll be passing captive insurance legislation in the next few weeks. And in general, we have wealth management services for clients. The Cook Islands, this is a quote from the Executive Secretary of the Asia Pacific Group on money laundering. The Cook Islands have emerged as a leader in the fight against money laundering and terrorist financing within the region. Certainly the regulatory framework and the robust legislation that we have has come under scrutiny in the last few weeks due to what some call the offshore leaks case or situation. We call it a theft of information. Our regulatory agencies are the Financial Supervisory Commission and the Financial Intelligence Unit, which now falls under the FSC. That came into existence in 2003. It replaced what was previously known as the Offshore Commissioner. And the Financial Supervisory Commission was the response to the OECD, FATF changes in regulations that all offshore finance centers found themselves needing to become compliant with. It's an independent body responsible for the supervision of regulated financial entities and financial services in the Cook Islands. So they come in every year, do compliance and auditing checks under our Financial Transactions Reporting Act, and they do that every year for the trust companies and the banks. And the point with them is to make sure that they have a robust licensing regime with a strong emphasis on corporate governance. There was also the establishment of the Coordinating Committee Against Money Laundering and Terrorist Financing. There was a move for the offshore industry to work more closely with the regulators in determining what worked with client situations and how everyone could make sure they were changing their policies and procedures internally to be compliant. There's active participation in the AML forums, such as the Asia Pacific Group, Egmont. Our commissioner serves on the board of the Offshore Banking Supervisors Group, and they work on sector capacity development. The Cook Islands is the only jurisdiction in the Asia Pacific Group that has no non-compliant ratings against the FATF's 40+9, and that was part of the results of the 2009 mutual evaluation report that everyone went through. We are number 2 behind only Singapore and the US, and as you can see by this chart that we were ahead of New Zealand, Hong Kong, Canada, Samoa, and Australia as well, which is not on this list. The tax information exchange agreements and DTAs that we all have that we're dealing with under the Global Forum. We have 17 TIEAs in force, several more in process. We do not have one with the U.S. They have not approached us for one. I'm sure they'll get to us eventually, but that's just one that we don't have at this stage. Nor do we have one with China. We haven't been approached by them either. We have requested a double taxation agreement with China and the United Kingdom for different services that we'd like to do that can better be handled if we had a double taxation agreement. We finished our Global Forum peer review phase 1 in June. Our report was released. We had a very positive report, and we won't have phase 2 until early 2014. So who uses the Cook Islands? As we heard yesterday from OIL, the main reason that people are looking to use offshore centers is for asset protection and wealth management planning. That certainly holds true for the Cook Islands. The majority of our clients are still from the United States, setting up trusts and LLC structures. However, we have a growing client base from Asia as well. Something as simple as us being this side of the date line and being one of the last countries just east of the date line, one of the last countries in today, I should say, and being halfway between Asia and the east coast of the U.S. are turning out to be advantages to us that have nothing to do with service and have nothing to do with our legislation, but we are seeing an increase from Asian clients as well. And we also have clients from other parts of the world. So I will turn it over now to Antony, and he will talk about asset protection.
Thanks, Jenna. Hope that's coming through okay. Yeah, it's great to see a lot of perspectives here at this conference this week, range of different people and professions. And with that, it makes it a little difficult to know where to focus a presentation on asset protection trusts. Firstly, I think it's good to have a look at some of the basic concepts and what really is asset protection to get that context. I think it's too easy for people to get carried away with terminology, carried away with preconceived ideas about what it is, and you know, the idea of people moving money away from creditors or the myth of tax evasion and so on. I have the quote up there: the legitimate planning in advance of any creditor problems to protect assets from any future claims for the long-term benefit of you and your family. It's not tax planning, we've heard that before. Asset protection trusts in terms of the US market are typically structured as grantor trusts, with income being taxed in the hands of the grantor. There may be some estate planning, particularly upon the death of a settlor or a grantor, but generally not tax planning. Of course, different forms of asset protection have been used for hundreds of years, from burying your gold in the forest through to the English using an early form of trust to protect their lands when they're going off on the Crusades, through to modern concepts of limited liability of entities to protect the owners from the debts of the business. So the concepts have developed. Concepts for asset protection have developed. Some of these with different degrees of protection, different uses, different circumstances. Again, corporations, LLCs, domestic trusts, foreign trusts, perhaps even simply moving to Florida, buying an expensive home and taking advantage of the homestead exemptions. It's natural for people, I think, when they've got something of value to want to protect it for themselves and their families. And the core function of trusts has always been to do that. It's always been to insulate the trust assets from the assets of the grantor from the settlor without passing title or control to the beneficiaries. So when we do talk about asset protection trusts, what we're really doing is emphasising what most trusts do anyway. They protect assets for your family. There are, of course, different degrees of protection, depending on how the trust was set up, where you are located, where the assets are physically located, the law chosen to govern the trust, etc. So using the term asset protection does indicate that the trust does have perhaps a higher degree of protection than what perhaps a domestic trust, for example. In many ways, the name asset protection trust is essentially a marketing mechanism, just highlighting one of the main natural reasons that people use trusts in the first place. Now, while a number of the basic principles have remained the same, laws in different countries, of course, develop differently. One example in the Cook Islands is that we don't have bankruptcy law. It just has not developed there. You can't make your debts go away. Theoretically, you can still go to jail for not paying your debts. On the other side of the equation, from a New Zealand and Cook Islands perspective, I suspect also from many of the Commonwealth countries' perspectives, we often really struggle with understanding the fairness of the US litigation system. Liability and damages awards have developed in a way that's pretty foreign to us. I understand from my colleagues here in the US that the plaintiffs' bar is actually quite a strong lobby group. So the chances of any reform in the area of civil litigation is probably quite remote. In that context, it's then not surprising that perhaps alternatives have developed to redress the balance back the other way. Trust law itself, of course, has always been a developing area. It's constantly changed over hundreds of years. While the basis is the common law, there's also been a statutory overlay found in trust law. In New Zealand and the Cook Islands, the legislation that's still in force is the Trustee Act 1956. English legislation is much older than that. In the Cook Islands, a new statutory regime came into place in 1989 to bring more protection to trusts, to create some certainty, clarify some of the trust principles in a lot of areas. In Nevis, their Trust Act was passed in 1995. In both Delaware and Alaska, they passed legislation in 1997, again bringing in a lot of certainty around self-settled spendthrift trust rules around fraudulent transfer and other trust principles. Now I understand there are 15 states in the US that have some sort of what you might call asset protection trust law. I understand Ohio passed their law in March this year. So developing concept, growing in many different jurisdictions. And we obviously now have this concept of wanting to protect our hard-earned assets. As I said, trusts have always been used for that purpose, and trust law is developed to offer a lot of choice in jurisdictions, choice in law, with varying degrees of protection and different features. So I'll move on and talk about some of the key factors in selecting an offshore asset protection trust jurisdiction. The first one that most people will look at is the legislation that underpins the whole structural regime in the jurisdiction. And a lot of it in different jurisdictions has common features, such as time limits for creditors to bring actions on fraudulent transfer, certainty around the non-recognition of foreign judgments, certainty around the ongoing role of the settlor, whether as a beneficiary or with retaining some element of control in the structure. So in selecting an appropriate jurisdiction, it is good to have a reasonable understanding of what those key provisions are and how they apply in the different jurisdictions. I have included in the materials a table prepared by Mr. Barry Engel, who kindly allowed me to put that in there. Obviously quite difficult to see here, and you may want to have a look in the materials at a later stage to get a better feel for the what has been identified as some of the key provisions that are found in legislation in asset protection jurisdictions, and how different jurisdictions have applied those. I guess one thing that I will say at this point is that the Cook Islands does get a tick in almost all of the boxes on there. But that's there for you to have a look at. So back to the main headings that I've got there. In backing up the legislation, something that's probably not focused on is the court system that's in place in the jurisdiction. And as well as having good law, it's vital that the quality of the court is there to back that up. And there's a few reasons for this. Firstly, the credibility of a jurisdiction. Any suggestion of bias or corruption or even just incompetence in the judiciary would undermine the whole effectiveness of a trust jurisdiction. From a settlor and beneficiary point of view, they want to know that in a worst case scenario, that the trustee in that jurisdiction is subject to the proper scrutiny of the courts there. And in the asset protection trust context, of course, you want to be sure that should a case make it to the court, and it is pretty unlikely, as in our experience in the Cook Islands at least, very few of these cases actually make it that far, but you do want to be confident that should that happen, the court is going to apply the law, they're going to understand trust law, they're going to be able to understand the situation well, and they're going to give a good and correct decision. In the Cook Islands, as Jenna has mentioned, our judges are appointed from New Zealand. They're all senior, well-experienced judges who get appointed to the Cook Islands Court. So they've got an excellent basis in trust law. They understand the law, and they're able to come and apply Cook Islands law in the Cook Islands Court. And we, of course, then have a very high confidence in our system and in the asset protection legislation that's going to get enforced. Moving on to history. Obviously, new jurisdictions, you don't quite know how the law is going to be interpreted. You don't quite know how the courts are going to treat it. What are the provisions really going to mean in practice? If a jurisdiction's been around longer, obviously you've got a much better idea of how that's been treated. Has it worked, put simply? And in the Cook Islands, we can emphatically say yes. The service providers, Who are the trustees that you're going to be working with? What are their capabilities? What's their experience? What's their ability to respond in a crisis? There's a lot of trust jurisdictions that have got excellent trust lawyers and trust law firms. There's no doubt about that. But in the context of asset protection trusts, have they been able to deal with difficult litigation and difficult situations with aggressive creditors trying to protect the trust assets? So you want to know the trustee has been through that, understands it. You want to know that they're not going to fold and hand over the assets at the first sign of any trouble. You want to know they've got a good network of attorney contacts, that they can deal with the issues, identify the issues, and manage their attorneys. And I think that's probably a key skill as well, because you don't want your attorneys running off and the bill all of a sudden goes sky high because they're focusing on the wrong issues. In the US context, you probably want a trustee who understands the tax reporting obligations. Although the trustees typically don't do the forms themselves, it will certainly help if they understand the process and the requirements. Question of jurisdiction can be important. And if a trustee has a branch or a subsidiary, for example here in the US, then an order against that branch or subsidiary could undermine the whole structure that's been put in place. I do have fees on there. I don't think it's a big factor, but obviously with clients it is. The only thing I think that I'd like to say there is I struggle to comprehend the idea of a trustee charging fees on a percentage of assets basis. I know there's trustees in jurisdictions where it happens. I don't think it's necessarily appropriate, but I'll leave it at that. And as I say, the fees I don't think are the crucial issue, and more important are the other factors that I've put up there. So I'll move on and try and go through some of the practical means of an action against an asset protection trust in the Cook Islands, some of the statutory provisions and how they would apply in practice. Firstly, on the enforcement of foreign judgments, and then the Cook Islands does not have any treaties for enforcement of foreign judgments. There is a misconception out there that means that the Cook Islands Court will not enforce any judgments in any case, any time, anywhere. That's not the case. We do have common law rules for the enforcement of foreign judgments. International comity principles apply, and if, for example, I was here doing business and ended up with a judgment against me for a particular reason that was entered in the US, if the creditor in that case could meet the common law requirements, which are quite strict, they could bring that judgment to the Cook Islands to enforce it. However, against an international trust, a foreign judgment is not enforceable or recognised if it is made inconsistent with Cook Islands law. Now, how many US judges are going to apply Cook Islands law? It's pretty unlikely to happen. Theoretically, if they did and they applied it properly, theoretically that judgment may possibly be recognised by the Cook Islands Court. But generally where we get to is that the creditor is forced into filing new proceedings in the Cook Islands alleging fraudulent transfer. The Cook Islands statute says that fraudulent transfer is the only remedy that's available. It's the only action that they can bring. That's the whole basis of any action that they bring. And on that point, I think it's very important, especially in the context of this conference, where we're hearing about fraud, we're hearing about those sorts of concepts, that we draw the real distinction between fraud in a criminal context and fraudulent transfer in a trust context. It can be quite misleading if someone is reading a judgment or part of a judgment, or even reading an article in the newspaper about a trust case where the word fraudulent transfer is bandied about. Fraudulent transfer allegations. This person has conducted fraudulent transfers. All of a sudden, a layperson will jump to the conclusion, oh, they've committed fraud. This is absolutely terrible. It's not the case. Fraudulent transfer is simply a statutory remedy to a creditor to gain access to trust assets. Asset protection trusts are not there to protect the proceeds of fraud. They're not there to protect stolen money. They're not there to protect money obtained by deceit. Is a transfer of property away from a current creditor of yours a fraudulent transfer? Well, it might be if you didn't leave enough money behind to pay them. Is a transfer of property away from a future creditor a fraudulent transfer? Might be in some jurisdictions, but the offshore jurisdictions have created certainty around this principle to say, no, it's not. It's not a fraudulent transfer. So we're now into the proceedings for fraudulent transfer in the Cook Islands, and there are quite a number of steps that a creditor will have to meet to try and get through this process. You see a number of them there, the practical barriers, then we get into some time limits, we get into the burden of proof, solvency tests, testing whether the settlor was solvent when the trust was set up, and even if they get through the various tests, collecting the judgment at the end. Hanging over all of this is the procedural law, strict requirements in terms of filing statements of claim, right at the outset, getting the facts correct in the affidavit, in the evidence. The Cook Islands law requires the plaintiff to set it all out, settle the evidence out when the statement of claim is made, and if they fail to do so, and they have to amend their statement of claim, they may then fall outside time limits. So in the US, where you might have a situation of filing a very general statement of claim, getting discovery, getting all the information in, digesting that, and then amending your statement of claim, filing a claim based on what you now know. Essentially a fishing expedition. I don't really know what I'm looking for. I'll file a claim, get the information, then I'll file my true claim. You won't be able to do that in the Cook Islands. You'll be likely to be out of time once you've gone through that initial process. Or in fact, you won't be allowed to bring it in the first place if you don't have the specific details of your claim in there. So running through some of these in a little bit more detail, talking about time limits. All legal systems have got principles of time limits applying to actions. It's nothing new. It's been around probably for 100 years as a legal concept, putting in place time limits for actions. The idea is to create certainty, so you're not left hanging there forever. In the Cook Islands, there's two types of time limits that will apply in a trust situation. The first is the limitation statute, which is a pure time limit. An action must be brought within 2 years of a transfer to a trust. Simple as that. If it's outside the 2 years, then you are time barred. Now this does apply to each transfer, so if I put $1 million in 2.5 years ago, that would be protected. If I put another $1 million in 6 months ago, that would still be potentially open to a challenge for fraudulent transfer. We also have what we call effective time limits, which are actually presumptions against fraud. These are based on the cause of action, the event that gave rise to a claim. For example, in the case of a doctor, it might be the actual surgery that took place which resulted in the error. In the case of a personal accident, it may be the crash or the event itself. If the transfer to the Cook Islands Trust took place before this event happened, there can be no fraud and therefore no case. If the transfer took place more than 2 years after the event, then there can be no fraud. There is an exception to that, as if proceedings have already commenced. So if we do get through these time limits and effective time limits, we get on to the burden of proof. The burden of proof is creditor specific. The actual creditor that is seeking to enforce must prove the intent against themselves only, not against all creditors. We do have the higher standard of proof of beyond reasonable doubt, obviously significantly higher than the civil standard. If we get through that level, we then move to the solvency test. As mentioned before, if the settlor was solvent after making the transfers, then there can be no fraudulent transfer. In working out those solvency tests, it's not the same as bankruptcy. It's not a case of assessing a settlor's position of all of their assets versus all of their debts and seeing if they're insolvent. It's against a particular creditor. Did the setup of the trust render the settlor insolvent against that creditor? The value of the assets at the time the transfer is made is also important. A simple example is 2007, for example. A client has a business with $1.5 million, they have cash of $5 million, and they have a potential claim against them of $1 million. Now, they set up a trust and put their $5 million cash into the trust. They are solvent against that claim because they are retaining assets of 1.5 million as against a claim of $1 million. 2008 rolls along, we're getting right into the depths of the Great Recession. The business collapses. It's now worth $50,000, and this is, 6 months after he set up the trust. Is that a fraudulent transfer? It's not, because he was not insolvent at the time the transfer was made to the trust. So the value of a client's assets, particularly the assets that are leaving outside of the trust, is very important in this context. Finally, if they get through those steps, we get on to collecting the judgment. The trust will not be void. The trust will continue. It's only the actual fraudulent transfers that were attacked that will be available in the judgment. All remedies will have to have been exhausted against other property. All rights of appeal will have to be exhausted against the settlor. As I say, only assets that are fraudulently transferred can be recovered. And in the Cook Islands, we don't recognise exemplary punitive damages, so they would also be excluded. So as you see, quite a lot of steps, quite a lot of statutory provisions, really adding, as I said, adding certainty into each step of the way through. The creditor is trying to use this remedy of fraudulent transfer. Consistent with those principles that have come through in our trust legislation, the Cook Islands does now have foundations legislation, and most of the same principles in relation to fraudulent transfer have been brought into that legislation. So those from civil law jurisdictions or people who are more comfortable using a foundation as a vehicle as opposed to a trust can still take advantage of many of the same principles that are there. I will quickly go through asset protection with the LLCs. Even in the domestic context, LLCs are used to a certain extent for asset protection. In the foreign context, they may be used for holding foreign property. They may be used as part of a foreign trust structure. In the asset protection context, we're really differentiating between the creditors of the LLC, of course, which you're not going to have protection from. The LLC has to be able to conduct its business. People have to be able to rely on the LLC being required to meet its debts. But we are talking about protection from creditors of the members of the LLC. The Cook Islands Act is based on a number of the US Acts, so many of the principles are the same. The issues that were identified included issues of whether a charging order was really allowed to be the sole remedy by the US courts, whether it would be identified as such. So bringing in some of that certainty, we were able to do that into our statute. So how would the creditor situation work in relation to LLCs? Well, creditor means a person with a Cook Islands judgment or a general assignee. No membership interests can be used to satisfy a creditor. Very importantly, the charging order is the sole and exclusive remedy available against an LLC. And that means you can't bring interlocutory orders, moreover injunctions. You can't bring foreign interlocutory orders and try and enforce them in the Cook Islands. It means that any foreign judgments that conflict with that principle cannot be enforced in the Cook Islands. And it basically, as it says, it's the sole and exclusive remedy. It brings it all back to the charging order and the operation of the charging order against the membership interest. So some of the features of the charging order. It is against the membership interest only. It is against that member only, so if there are multiple member LLCs, then it's restricted to the member that has the charging order against their interest. Again, we don't include punitive damages. Importantly, it doesn't affect other membership rights. So the business can continue to operate. You can't seize the assets, you can't interfere with the management, the business can carry on. As long as it doesn't make distributions, then the charging order is not really a whole lot of use. It will expire after 5 years. You can probably apply for a new one and keep doing so. So in conclusion to my part of this session, asset protection really is about the legitimate organisation of your affairs and assets for the benefit of your family. It's not about tax advantages. It's not about hiding assets, not about secrecy. In fact, in a number of cases, the attorneys for a settlor may choose to disclose the trust to creditors at quite an early stage. They may be quite happy to say, hey, effectively say, hey, even if you get through this whole process, if you get to the end of this, this is what you're going to be up against at the end of the whole process. And that in itself can help encourage a reasonably fast resolution to proceedings. Similarly, from a trustee point of view, we're more of the mind of, hey, here we are, come and get us. It's not hiding, we're here, you know where we are, come on over. So you do want the best legislation. You do want very good legislation in place. It is important to look at the features and the factors that are involved, but it is a lot more than that. You do need to look at the whole package. What are the service providers and what are the courts that are backing up the systems that are in place? And on that note, I will hand back to Jenna to continue for us.
Just a few more things, then we'll open it up for questions. I just kind of wanted to end with where we're at in 2013. We've certainly had a lot happening in the last month or so. We're about to hear a session from one of the reporters from the ICIJ that has certainly affected the Cook Islands, given that one of the trust companies that had information stolen from it in the BVI also has an office in the Cook Islands. But what we've been hearing a lot about over the last couple of days is privacy versus secrecy. We keep hearing that anything offshore is all about secrecy. Well, in a 2013 world, secrecy does not exist, nor has it for the last decade. Any financial transaction under current international regulations is certainly may be private from those who a client does not want to hide it from, but it is not secret from any authorities. As I went through our regulatory structure, the banks, FIU, FLC, the trust companies, everyone is aware of that information. And under the new standards with the Global Forum, you must have beneficial ownership information. In the Cook Islands, we technically have nominee shareholders and directors still on the books, if you will, but we have a draft overhaul of our International Companies Act, and we will no longer have those. And practically speaking, we only have a handful in existence anymore anyway. We saw yesterday afternoon, Jack Bloom had the Wiley brothers thing with Senator Roach, and it was such an example of what not to do with international planning, or what not to do with any type of planning. And I've always been of the view, particularly from my time in the private sector, the simpler the structure, the better, given your client's particular circumstances. Now, that's not to say that it might not require many layers in terms of trusts or companies, depending on what they're doing and what assets that they're trying to hold. But the simpler the structure, the better. The idea is not that you're hiding anything from anyone. It's that you have strong foundations. It's not secrecy that makes a structure work. It's the strength of the legislation underlying that entity. So I think that's something that we have to keep in mind. Keep those structures simple. It's about privacy, not secrecy, and we've certainly seen a lot of individuals' privacy who's been breached over the last month. Compliance is important as well. The Cook Islands, just like everyone else, and the trust companies and banks there are gearing up for FATCA, and we've got changes coming to our legislation. We're putting in some amendments so that the trust companies and the banks can comply when FATCA does come into effect. And there's certainly a commitment by the government to the industry. It's very important to a small island economy. I know several of you in here are from similarly physically similar jurisdictions, and the importance of such an industry to them. One of the things that's been very frustrating, and I'm sure my blood pressure is going to go up in about half an hour when we start that ICIJ session, is that this was not a leak. It was theft of information, and it's the trust company involved that we deal with in the Cook Islands that's been impacted. They have filed police reports in the relevant jurisdictions, and they're taking it very seriously because clients aren't coming to us to hide anything, and what hasn't come out into the media is the tax compliance forms that would have also been part of that documentation that was there. And it's difficult. I think I've got a colleague or two in here from the BVI. This hasn't come down to the two trust companies involved. It's come into the two main jurisdictions. So you can imagine the frustration that when you only have one side that's getting out there. And there have been some good articles on the other side from Wall Street Journal and looking at other aspects of that. So with that, we'll close things out. I think that's my last slide. The Cook Islands is certainly a place that, for those of you in the private sector, we are looking to expand in terms of service providers, and it's a great environment to come into. It is well regulated and well regarded by the international authorities in this 2013 world we're navigating. And also, from the compliance side, we have, as Antony said, there are very specific things in place with our legislation for those of you that find yourself on the other side needing to come to the Cook Islands. So, does anyone have any questions? Sure.
all the amounts that we had held at the Cook Islands
I know the reference that you're making within that. I can't speak to that person individually or their situation. I also will say I'm not well versed on Canadian tax law. I can speak much better to some of the compliance issues from the U.S. and the requirements. But in general, how it works is a client's attorney, or sometimes their financial advisor, but usually it's an attorney, they are the one that is referring the client to the trustee. And in general, if a client went directly to, say they came directly to Cook Islands Trust to Antony, his response is going to be, here's our information, bring this to your lawyer, and have your lawyer get in touch with us, because it's really important that whoever is setting something up offshore have someone in their home country on the domestic side. One, because chances are they're not going to send somebody to an offshore trustee company that's going to reflect negatively on them should anything happen along the way. And also, it means that there's someone in the picture that can advise on their home country tax obligations. So while the Cook Islands Trust Companies are very comfortable and quite frequently are filling out or signing off on the tax forms that are prepared with regard to the trust tax returns and the Form 3520s, Form 3520As, they don't necessarily know all of that person's tax obligations elsewhere in their home country or any other country that they're doing their work in. So the reliance has to be on that client's tax advisor, which is not the role of an offshore trustee. They'll certainly assist in compliance where they can, but they can't know everything that a client has. Typically, a client that's setting up a trust in the Cook Islands, they're doing so, it's one part of their overall estate plan. They're not putting everything they own in there. We certainly don't recommend that. It doesn't look good if they ever found themselves in front of a court, and it's usually that extra layer of insurance that you can't get somewhere else. That worst case scenario where you lost all your other assets, you still have some left, for some unforeseen circumstance.
But are you aware that some people are using the kind of protection that are offered to simply hide assets and not pay taxes in their main country?
I forget the years in which he was there. The regulatory regime has changed in the last 10 years. It'd be very difficult for someone to transfer, for example, $1 million from Canada to their trustee in the Cook Islands, and that may not be the ultimate banking center. The Cook Islands is not a banking center, so chances are there's bank accounts in other places, and maybe the trust has a bank account in Canada. The authorities in today's world are going to see that money moving. If there's any suspicious activity, then either at the Cook Islands end, if they had reason to believe so, but more so you'd see it on the Canadian side, they would file a suspicious transaction report or suspicious activity report, I think it's called in the U.S., but we call it an STR. Yes.
Nominees, if they were no longer, they're regulating nominees or they're doing away with them. That's the story.
Well, with our phase 1 peer review, that's one of the things that the Global Forum has put out there, that bearer shares and nominee, you can still, I think it'll get to a point where you will not be able to have bearer shares anymore. That's just the way, that's just the way the world's moving. But nominees, in fact, I think I may have misspoke there. I should have referenced bearer shares. But even with nominee directors and shareholders, everything is moving towards making sure that the ultimate beneficial owner of any entity is on there.
Rules for the nominee, in other words.
Yeah, so you're going to have all that information, and it's a little bit stricter.
Other companies, other jurisdictions would be a nominee.
Yeah, and you're still going to have to keep digging back till you get to that ultimate beneficial owner.
LLC is the nominee for Cook Islands LLC. Would it work that way, or they wouldn't allow it, or it's prohibited by law?
You can do that, but you're still going to have to find the ultimate person, the individual who's at the end of that chain.
Bounce over there, and then they'd have to bounce back to the other side of the world to figure out what's going on within the other LLC that's basically the nominee for the other entity.
Technically, you can do that. I can say in practice, that's not very common. I think Antony
I've seen
could
it
see
where
the,
they've had to
yeah.
bounce around 15 different jurisdictions.
But that's getting very far away from the simpler the structure, the better for a particular client situation. Yeah. Yeah.
That was something, I was a government entity that actually did that. But that's
Okay. Any other questions? Yeah.
Comparing the different jurisdictions, if that's available.
Yeah, we can, if you leave me your card, I'll email it to you. It might be able to come through more clearly than it does on the PowerPoint.
Publish it online as well, I think.
Yeah. We'll have, and this will be available online, I think, over the next couple of weeks, yeah.
On OffshoreAlert website?
Yeah, all of the presentations will be put up, yeah. Any other questions? Well, we can head down to the break, I guess, and then hear what the 4:30 presentation brings.